Good afternoon. If you are just joining us, my name is Rebecca Sharp and I'm an archive specialist, and I provide reference services at the Washington, D.C. location of the National Archives. Before we get started, I have a few things to go over. You can submit your question for a speaker via Twitter using hashtag GenFair2014, or you can chat with us on YouTube chat. The speaker may not be able to answer all of your questions in the allotted 10-minute Q&A session. Captioning for the virtual fair is available on the fair website, and click on the link for today. The lectures will be recorded and they will be available on the fair website by the end of November. This is our final lecture. It's lecture number 17 if you're following along on the schedule. It is entitled Patently Amazing, Finding Your Family in Patent Records. Our speaker is Christopher Magee. Patent case files offer a unique genealogical perspective as they contain biographical information, show intellectual pursuits, and detail the products your ancestors created or improved upon. Learn what information is available and how to access the over 4 million case files held by the National Archives. Christopher Magee is an archivist with the National Archives at Kansas City, Missouri. And I'm turning the microphone over to you, Christopher.
Hello. I'm very glad to be here today. And before I begin and get to share this, have this opportunity to share this tremendous resource, I would like to thank all of the other presenters who have given their time. I'd also like to thank Andrea Matney and Rebecca Sharp for doing their organization of this event. And I'd also like to thank you, the attendees. Without your participation, this program wouldn't be possible. And so I hope you all have an opportunity to get out there and learn and explore a whole bunch of new records and fill in some of your family histories. Today's presentation is Patently Amazing, Finding Your Family in Patent Records. Primarily today, we will be focusing on patent case files. These are records that relate solely to the actual granting of a patent by the United States Patent and Trademark Office. Will be to identify what a case file is. We will then learn about the history of the Patent and Trademark Office and how this may impact your research. We will describe the genealogical benefits found in a case file and walk through an example, and you guys, so everyone can see what is actually available in a standard file. We will learn ways to locate patent numbers, and then also understand how to search for and order files. One of the things that's instantly apparent once I started providing reference on these records is that these are a very fun group of records to work with. And this patent here is actually kind of what really got this ball rolling on me sharing this with internal NARA staff. A colleague of mine was watching a TV show, and in this, it was a pawn show where they got a storage locker, and in there was a bunch of eye protectors for chickens. And they thought, hey, it'd be interesting to see if there was an invention, a patent for that. And sure enough, they found one. This was granted in June 1916, in 1903, to an Andrew Jackson Jr. of Munich, Tennessee, for an eye protector for chickens. And it's a good example of you never know what you're going to find when you open up a file. And so with that, a little bit about the National Archives. For anyone who is attending this fair for the first time today, the National Archives, often called NARA, holds the permanently valuable records created by the federal government. We have offices around the country, from Boston to Seattle to Riverside to Washington, D.C., and more. And the facility I'm based at, the National Archives at Kansas City, is pictured here. As has been mentioned in previous presentations, the National Archives at Kansas City holds records created in Iowa, Kansas, Missouri, Nebraska, as well as selected Minnesota and North and South Dakota records. So this leads to the very interesting question is why are records created by the Patent Office in Washington, D.C. and Kansas City? Due to the overall size of the holdings, they were moved off-site for space concerns. NARA actually has 3 off-site facilities in Kansas City. As was mentioned, we have over 4 million patent files that were granted, and if you laid each of those boxes end to end, it would cover over 323 football fields. So we have a lot of records, which is great because that means there's a lot of chances that your ancestor is included. So the question comes up is, what is a patent? A patent, in its most basic terms, is the granting of a right or title by a government authority. The United States Patent and Trademark Office, often called the USPTO or just simply the Patent Office, defines it as a property right granted by the U.S. government to an inventor to exclude others from making, using, offering for sale, or selling the invention for a set period of time. Patent rights were not something that was granted in perpetuity. They were granted for a certain set of time, and the reason is so they have to publicly disclose in order to gain that sole right. One of the things that you'll also find is the word patent doesn't always necessarily mean patent. For a long part of its history, the Patent and Trademark Office was underneath the Department of Interior, and they would also use the term patent for land records. And that's where we get to the true original definition of patent is the conference of a right or title by a government authority. The government was granting land, which they called a land patent. What I'm talking about today is solely inventions. Patents are also different from trademarks. Even though this is part of the same agency, trademarks represent a wholly unique set of records and are not reflected in the records I'm talking about today. What really can be confusing is the Patent Office would use the term patented to mean trademarked. If you zoom in on this picture here, it has a serial number and a date from the U.S. Patent Office. So this very much looks like it's going to be a patent case file. This was actually a trademark. This was a reference request that I worked with where the person came to me, and through researching we were able to use context clues to determine that this was actually a trademark and not a patent file. These are also different. Patent files are also different from copyrights. Patent files relate to an invention, whereas copyrights relate to protecting the authorship or creative work, and those are actually maintained by the Library of Congress. Oops. So one of the reasons why the National Archives, has the patent records is that the patent is actually a constitutionally protected right. In Article 1, Section 8 of the Constitution, it says, "The Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries." And in fact, the first Patent Act passed in 1790 was called an Act to Promote the Progress of Useful Arts. This was part of the Secretary of State's office and patents were granted by the Secretary of State. The very first patent that was ever granted in the United States was a colonial patent in 1641. This was a colonial record where the Massachusetts General Court gave Samuel Winslow an exclusive right to utilize the process for making salt for a period of 10 years. This is not part of NARA's holdings, and it is unofficially known as the first patent in America. So as the patents began in 1790, they very quickly became pretty popular, and by 1836, it had gotten so overwhelming for the Secretary of State that they established their own patent office. And this is a really seminal year in patent history. This began our modern numbering system. Patent number 1 was granted in 1836. It granted inventors 14 years. They had the sole rights to their patent with an extension up to 7. And it also removed U.S. nationality and residency requirements, so this meant foreigners could apply for U.S. patent protection. Another reason 1836 was such a monumental year was there was a large fire on December 15th of that year. There was approximately 10,000 patents that were destroyed in the fire. Of that, only 2,845 patents have been restored. These patents are called X patents because they have been given an X number that precedes the patent number. So this, what I have up here, is a patent granted to E. Insure for a harp guitar, which was patent 6788X. And the X is the signifying that it was destroyed in the fire and reconstituted. In 1849, the Patent Office moved out from the Department of State and became under the Department of Interior. They would be under the Department of Interior for about 75 years. In 1864, patent law was amended so that once a patent had been applied for, no new information could be added. And so what this means is if you had one invention and you did a slight change to it, if you wanted to secure and protect that right, you would have to file an additional patent. So if your ancestor has one patent, that at least increases the opportunity that they may have 2 or 3 or even more. During the same time, patents also became an epicenter of Washington, D.C. tourism. They displayed models. The Declaration of Independence, which is now in the National Archives in Washington, D.C., Andrew Jackson's military uniform, a piece of Plymouth Rock, artifacts from Commodore Perry's expedition to the South Pacific and Japan. And the Patent Office was actually, in fact, the first federal building to host an inaugural ball. And pictured here is, that was with Abraham Lincoln. And pictured here is his bill of fare for the second inaugural ball. Another distinction of Abraham Lincoln is he is the only president to have been granted a patent. He was granted patent number 6,469 in May of 1849. And this was a method for buoying water vessels over shallow water. And in fact, when Lincoln was during his presidency, he would often take his son Robert Todd to visit the patent building, and also often spoke about the value of patent records. So after the 1836 fire, Congress actually commissioned the new architect to build a fireproof building. And unfortunately, that did not happen. And in September of 1877, there was another fire. This was more costly and damaging than the 1836 fire. Approximately 600,000 prints were destroyed in the fire, but astonishingly, there was no complete loss of an individual patent file. The biggest loss in the fire was the over 87,000 miniature models that had been destroyed. By then, that was one of the really fun things that people went to go see at the patent building. And in 1880, the Patent Office dropped the requirement for miniature models to be included in the application, and those are not found in any case file. Those are considered an artifact and were not maintained with the original record. In 1925, the Patent Office moved into the Department of Commerce, and that is where it still is today. In 1952 was another major overhaul of the Patent Act, and they stated that patents must be non-obvious and that inventors must detail the basis for an infringement of their rights. And what I have here is an example of what I would consider a very obvious patent. This was granted to a person in July of 1928 for a toy representing a turkey gobbler. I don't know the purpose of this invention or how it was granted a patent, but this is something that would likely not be granted today. In 1975, the Patent and Trademark Office merged into one. It used to be from the 1800s through 1975, there was an individual patent office and an individual trademark office underneath their various departments, and now we have the United States Patent and Trademark Office. And even in more recent history, there was the 2011 Leahy-Smith America Invents Act, and this was a fairly big change in patent law that switched patent protections from the first to invent to the first inventor to file, and the United States was actually one of the last countries to make this switch. That won't really impact any of the records that I'm going to be talking about today, but it's just something to keep in mind when researching more modern patents. What's really interesting to see is how popular patents have been. We generally have at NARA patents from 1836 through 1976. In 1836, 702 patents were granted. By 1976, 74,790 patents were granted. And this is when we really see an explosion. And last calendar year, over 301,000 patents were granted by the United States Patent and Trademark Office. So we really, in the coming decades, are going to have an explosion of records that have been created. So, what is in a case file? And this is really what I'll be getting into and talking about the heart of it. This is really where the fun stuff is. Granted files are going to contain the initial petition, application, and oath of an inventor. There will be correspondence between the inventor, their legal representation, and the patent office. And as these are granted patents, there's going to be what's called a letters patent, which is the published description and drawings produced by the USPTO. Note, case files will not cover what happened after the patent was granted unless there was a lawsuit or infringement filed. So if you're looking into what happened to the rights of the patent, that will not be kept here. This is documenting the federal interaction, which is the initial granting of that right. And one of the best things about every patent file is that it's going to contain signatures. And this was actually a patent that was granted to Samuel Clemens, better known as Mark Twain. This was a patent he received for scrapbooking, which I think is amusing. He also received 2 other patents, one for suspenders and one for a historical memorization board game. So in terms of the genealogical benefit, I already talked about how they have signatures. This really is one of the great gold mines of the patent files to me, is to see your predecessor's work and them signing it. It's just fun, and it's great to see. You really get to learn about your ancestors' professional and intellectual work. Sometimes patents were granted in the course of working for a business, like an oil company or a chemical company or a design company. And sometimes it's just on their own. This is something that they believe is valuable and worth trying to obtain the rights for. It can contain geographical information. This is not always guaranteed to have addresses or anything like that. A lot depends on the age of the file and whether or not they retained an attorney to work with the patent office. And you're also going to get tangential socioeconomic information. Applying for a patent costs money. When the patent was granted, it cost money to obtain the grant. And further, did your ancestor retain an attorney? All of these things cost money and tell you more about your ancestors' priorities, but also whether or not they had the means to do this. So when we're talking about the genealogical benefit, I'm actually going to talk about and go through a case file for my own great-great-grandfather. If you're following on the handouts, I have provided an entire copy of this file in case it's hard to read that you can download on the virtual genealogy page. And what I will be doing is walking through this step by step and highlighting some of the unique things you can find. And I can actually say this is very much a standard case file. The records that I find here, you could expect to find in about any case file we have. Most case files tend to be 35 to 60 pages. If there was a lot of contention, I've seen patents as large as 300, 400 pages, and as small as 7. It just really depends on the age of the file and what all went into it. So this is patent number 452,846. This was granted to William Joseph Magee on May 26, 1891 for an improvement in churn power, which is basically a mechanized churn. This is the wrapper that contains the records. Before about 1900, all of the records are trifolded, so this does have preservation and access concerns just to be aware of when ordering or viewing files. After the 1900s, the records were filed flat, and preservation concerns on that are much lower. So Willie's file was trifolded, and on the back side of this, there was an index, and this index contains every filing that the Patent Office put in there, and generally that's going to be pretty accurate. They did a pretty good job of keeping records in there. The one thing I can say is the published letters patent is not always in the case file, but you will get the initial application, correspondence back and forth. The index on the back of the file wrapper will contain the dates of filing, what was filed, and so you can really go through and track. Oftentimes, while the patent files are in the boxes numerically, in numeric order, inside the case file, they're not necessarily put in chronological order. They were just kind of placed in the file, so you might have to do some sifting to get it in chronological order if you order reproductions. So what I have here, this is a copy of the petition. And if you do order patent files through the National Archives, I strongly recommend using scans. You can get little pieces of color, and I think the records just show up better. And every patent is always going to begin with a petition, an application, and an oath. These are often all put together in one filing called the application. And this is where the inventor is stating that they know to their best ability that they are the sole inventor of what they are claiming. I also really like the petitions because you often get really cool letterheads, like the Samuel Clemens Oath. This patent for the butter churn was granted by William used a patent attorney and was able to have great little letterhead on the front for the C.A. Snow and Company. And it's just really, I find, very visually appealing. It has a lot of pop. So one of the things I'm going to note really quickly, and what these are the types of things you can expect to find, is William Joseph Magee was his full given name. However, when he signed the petition in power of attorney, he signed it as Willie J. Magee. The notary public who notarized it signed it as William Joseph. And this is something that's going to come into play as the application process went through. And here's just a close-up where you can see the discrepancy between the Willie J in the middle under specification, at the top, the William Joseph. So then we get to the actual application itself. Most of these are TypeScript. If you get to inventions in the 1880s and previous, from 1836 to 1880, they're often handwritten. And if you're looking at this, this is another reason why I highly suggest getting scans, is you can get color copies and you can see all the scribbles and the notations that the patent examiner made to the application. This just kind of helps give you visual clues as to what your ancestor did, what the patent office did, what was changed, and just generally helps with the reading of the file. Each initial application will end with the oath. And like the front page, like the front petition, it was signed as Willie J, and the notary public signed it as William. So again, keep this in mind. So if you're following along in your handouts, we're going to then come to a letter from September 3rd, 1890. This is a letter from the Patent Office to the inventor or their representation. And basically this is them stating, we've received your file, this is our initial review. In this letter, the Patent Office says you have basically two claims and you need to decide what you want to pursue, because you can't have two claims in this invention. And so the patent attorney filed an amended claim where they canceled the first one and chose to go with claim 2. So they would not have as much work to go through. Everything seemed to be going along very smoothly. And so that was December 12th, 1890, when the amended claim was submitted. On December 27th, the Patent Office saw a discrepancy, and they wrote, "It is now noted that applicant's Christian name is given in the petition preamble and the oath is Willie, while the signature it is written as William. The preamble should therefore be amended and a new oath furnished in order that they may agree with the signatures." And so this is the 1890s. That's going to, cause some time. It's going to cause some delay. So in the next amendment, the patent attorney argued that the inventor signs the name William throughout the papers. There being no discrepancy in the signatures themselves, it is thought that the requirement is groundless. Aside from this, Willie is merely a contraction of William. Well, unfortunately, this letter was from January 3rd. On January 8th, this did not appease the patent examiner. They say, "Is the practice of this office does not permit the amendment of the oath, the substitution of William for Willie therein as requested. By the amendment cannot be complied with, and a new oath is therefore essential. The argument that Willie is a contraction of William and that the requirement as to the correction of names is groundless is not well founded. Willie is no more a contraction of William, as stated by counsel, than is Bill. Both are nicknames." So if the Patent Office says that, and if you want to get it granted, you have to follow what they say. So correspondence obviously went back and forth between the attorney in Washington, D.C. and my ancestor in Texas, and a new oath was furnished where it was signed as William J. Magee. And one of the things that just kind of makes me laugh at this time, it was actually then they conflated where he signed it as Willie. So he had to go back over his oath, re-sign it in different handwriting to actually make it agree so that the patent could be granted. So very shortly after the new letter was received, the patent said, "Okay, great, we can go forward through this. The case can now be considered." And here they go through and talk about some of the language in the patent that needs to be used. About a couple weeks later in April, there's another response from the attorney submitting a new claim. And then a month after that, there was a notice of allowability, or 2 days after that, was a notice of allowability stating that this patent was now acceptable to be granted. After the patent has this notice of allowability, you still need to pay your final fee. And in this case, the final fee was $20 that was paid on May 1st, 1891. And when I talk about the hidden socioeconomic information, the filing fee was $15 and the granting fee was $20 for a total of $35 in 1891. Using a couple different inflation calculators, that roughly corresponds to about $894 in today's money. And not only that, Willie contracted an attorney to help him go through this process. So this is all telling me that he felt this was important enough for him to go through this process. And, you know, before I had found this patent, this wasn't really, my family didn't know much about him. About the only thing I had known previously was that he had built the first building in the town of Groveton, Texas, where he was from, which was a saloon. And so this provided a whole nother insight into the life that he led. So after the fee is paid, and that's received by the patent office, the inventors receive a letters patent. And this is, again, the published drawings and description of the patent granted by the patent office. And you can see that the United States Patent Office granted this to William Joseph Magee of Groveton, Texas, for churn power. And the best part is, this isn't every patent, but oftentimes you will get a drawing. These are very visually striking. These are fun. I've had many researchers who order high-quality scans of this because they want wall art. And they want to have something their family produced. And this is actually, it's fun. It's like I've used that word before, but I really believe it. And getting to see my own ancestors' record is just, it's a cool thing. And so here's a close-up zoom in on the published drawing. So a little bit more about what the National Archives holds. As has been previously mentioned, the National Archives divides records into their creating agency and assigns them a unique number. For this instance, we are going to be talking about Record Group 241, records of the Patent and Trademark Office. And primarily what we have are two main series. Series are unique sets of records, and we have utility patent files and design patent files. And I'll get more into their distinctions in a minute. Both case files contain very similar documentation relating to the application, correspondence, and issuance of the patents. So William's patent that was granted was an example of a utility invention. These are functional inventions that are granted. Design patents are strictly ornamental in nature and have no functional improvements. There are also much fewer protections over a design patent. And this is a very good example of one. This was a blouse that was granted in 1936. Basically, just the way it was designed, this inventor felt it was worth patenting. And the inventor, who it was Albert Einstein. He received 2 U.S. patents that are known. There's this patent for a blouse and another one for a refrigeration system. So utility files really represent the major bulk of our records that the National Archives has. We have patent number 1 through 3,944,724, which was granted on March 16, 1976. There was also a special early accession of patent case file 5,255,452, which was a patent granted to Michael Jackson for a method and means of creating an anti-gravity illusion. These are the special shoes that he wore in his music videos, and that is fully available on our online catalog. So really think that currently, so while our overall records span to 1993, they really end in 1976. And this patent located here is a patent that was granted to NASA for the first human space capsule that was used in Project Mercury. And so that's one of the other things to really keep in mind is when doing your research, patents were granted to organizations, they were granted to businesses. And so there are lots of opportunities that your predecessors may have been able to be involved with that just really expand the opportunities to have positive results in the patent files for you. Design patents we are not as common. There were only 229,224 design patents that were granted between 1843 and 1973. Again, these are just ornamental in nature and don't actually relate to functional improvements, so there's not a lot of overlap. There's just not a lot of applications, excuse me. There is, however, some overlap between trademark material and what you can find in a design patent. One of the requests that I receive a lot is the patent for Coke's formula. That actually does not exist. That is kept under as a trade secret. And this is actually a design patent that the Coke company received for a bottle. This was granted in 1915, and so obviously the patent rights on this are well expired, but because it had become so ubiquitous with the Coca-Cola brand, the bottle shape was trademarked, and so even though this patent right has expired, other companies can't use and reproduce that. Similarly, I've also seen design patents for toys designed by Walt Disney. And so while Walt Disney will have a design patent, that doesn't mean that person can just go up and create that toy because it would have other associated trademarked or copywritten material. So one of the other aspects of research that this can lead to are lawsuits. And since patent rights are a constitutional right, all lawsuits are inherently federal in nature. So we have interference proceedings that are worked through the Patent Office itself, and those records are maintained at the National Archives in College Park. And then we have our federal court system, and that really can be anywhere in the country. There's district courts, the Circuit Court of Appeals, as well as Supreme Court patent-related cases. There's also an individual Court of Customs and Patent Appeals. That's Record Group 503. Those are also held off-site at my facility. And the picture I've included here was a suit from the U.S. Circuit Court of Appeals, the Second Circuit, which is in New York City. This was a Wright Brothers lawsuit against the Curtis Herring Aeroplane Company from 1909. And they sued the Curtis Herring Company over their patent to heavier-than-air flight, and this was an image that was submitted as evidence in the proceedings. So if you can find out some additional information, you can really sometimes get some amazing resources. And like I mentioned earlier, if there was a lawsuit involved with the patent, there will be corresponding documentation in the case file, which will lead to these further avenues of research. To see what records NARA has online about concerning Patent Office, go to www.archives.gov. At our main site, you will click Research Our Records. That's on the left tab. And then there you will look for the heading search online and click your online catalog link. You can also go directly to www.archives.gov/research/search, and that will take you directly to our search page. From there, I highly recommend using the advanced search feature. Because the term patent was used for so many things, if you just type patent into our online catalog, you're going to get a lot of false positive searches or results. So I highly suggest then clicking the triangle next to filter archival descriptions and restrict your search solely to record group 241. We currently have 57 unique series. I have listed in the handouts numerous other series that are highly pertinent and of high research value that are located under the patent USPTO. Additionally, we do have some records that have been digitized. If you search for the record group number, you can then see what records are already digitally available. Some highlights are the Michael Jackson patent, as well as Joseph Glidden's patent for barbed wire, and numerous drawings that are held in a distinct series that I'll get to in a minute. So one of the things that's important to note is if you're using our online catalog, you cannot find a name searchable index online through the National Archives. And obtaining the patent number is the key thing we need to locate when trying to determine access. These files are stored sequentially, so box number 1 has patent numbers, starts with patent number 1, and our most recent acquisition of holdings has our last patent 3,944,724. So determining that patent number is what we need to determine when working with the research request. Starting in the 1880s, each patent was assigned a unique serial number upon application, and then the unique patent number. So the serial numbers will kind of circulate through, but they'll have addendums before. To kind of learn more about serial numbers and what years are applicable, I have included the following websites. And this is what's really key when determining whether or not something is a trademark or something is a patent. And if your research inquiries lead to that, we will cover it when the reference request comes in. So how can you find a patent number? If this is the key, the best resource I suggest is Google Patents. The United States Patent Office has an online searchable form for patents 1976 and forward, but from 1790 to 1976, it is not named searchable. So I really suggest general Google searches, and Google Patents is a very tremendous one. It allows a lot of flexibility in using terms, and it creates an entire searchable letters patent. It's very important to note that when searching online, you can find the letters patent, but all of the correspondence, the petition, the application, the correspondence back and forth, that is all only available through the case file in paper record form. That is not available online. Another opportunity you can use, another website is Free Patents Online is another search one. You can also find at some federal depository libraries patent gazettes, and that will be yearly publications of what patents were granted. Because again, one of the key factors in granting a patent is that you have to publicly disclose how you got that invention. And so you get that published letters patent. So like I said, I really highly suggest Google Patents. If you type in Google Patents, it'll be one of the first searches. And when you go to the Google Patents search page, which I am here, it looks very similar to just the standard Google portal. But you can tell when you're there that you're specifically searching patents. So when I began referencing these things to kind of learn how, this was the site that was suggested for me to learn how to use. One of the big things with Google Patents is that because the entire letter's patent is searchable, that really creates a lot of opportunities for hits. One of the problems is that because a lot of patents are old, there's a lot of mistranscriptions in the description. So it's very important to not search for an entire name. It's to search for bits and segments, because you don't know if your ancestor would go by their initials, they would go by their full name, would they go by nickname? It all depends, and so you really want to be selective in how you search and start as broadly as possible and not very narrow. Another good tip is just use your last name and the location your family was known to have lived, and that's a good way I have found to narrow down results. So this is the first 4 hits I used when I was searching to see if my family had any patents, and I searched quotes for Magee and a quotes for Texas and was able to find 4 hits. I did not know of a Richard or a Samuel in my family tree, but I saw that there was a W.J. Magee and that it went by William, and I was like, hey, I knew that I had that in my family tree. And so I clicked on it, and this is kind of zooming in, and this really highlights the different terms you'll find. It is actually listed in Google Patents as being granted to Joseph Magee, and that W.J. Magee is the inventor, and a horrible misspelling of Groveton. So again, it's one of those things where using individual quotes, you're able to find those hits throughout the letter's patent and not all in one string. It's very rare to actually find that in older patent files. And then this is what the search will look like. This is the results that will come up. And then finally, you can actually, like I said, you can find copies of the letter's patent online, but they're very low quality, and I personally like having the opportunity to have a very nice image of the patent. So when troubleshooting your searches, a lot of times patents are family lore. And just because an ancestor applied for a patent doesn't mean that they were granted one. And so one of the things you really want to make sure is that you are looking for a granted patent and not a rejected application or a trademark. And this is when the contextual information will able to help confirm your family's stories. When you're searching online, try a lot of different search terms. And that way you can get a lot of different results. I have found that if you know basic geographic information about where they lived, even the state can be incredibly helpful in narrowing down. If you know your ancestor worked for a company, you can also try searching for that company's name. The big thing is, with the older patents, especially online, there are a lot of transcription errors. And so it will take a lot of unique searching, but it's stuff that you can start it at home. Google Patents is a free search engine. There's no registering required. And then once you find that, you can contact the National Archives, and we are glad to pull and make these records available. And the last thing I would also want to make sure is that you are actually looking for a United States patent. There are patents that were granted by the UK, Germany, Canada, and making sure that you're actually looking for a patent granted by the United States and not a foreign country. So if the records aren't at the National Archives, where can you find them? So records from 1976 through today are accessed through the United States Patent and Trademark Office. To obtain access, you want to contact the File Information Unit, and I've listed their phone number here as well as the website for ordering online. One of the things that's important to note is that you can obtain access to granted patents only, so if you know a person whose application is still pending, that cannot be publicly made available. Further, if you're looking for a modern federal lawsuit, that's going to be at the court of filing. Generally, we have lawsuits that are between 15 and 25 years old before they are eligible to come to the National Archives. So there is going to be some differing time periods with that. So when ordering with the National Archives at Kansas City, provide as much information about the patent as you have. If you don't have that, I'm glad to work with you a little bit and figure out what we can do to determine whether or not there's actually a patent number. If you want to view these records in person, you are more than welcome to come to our facility. We are located in downtown Kansas City at 400 West Pershing Road. It's in the Crossroads Arts District. But as these records are off-site, we need at least 2 business days advance notice to facilitate the transfer of records to be publicly viewed. And really, if you're coming here to view records, if you can give us a week, that's great. If you give us 2 weeks, that's even the best. So that way we can ensure the day you come to visit and you put in your pull request, the records are available for you right then and there. And I've also included this in your handouts just as a basic way to write us, and you can send your request to kansascity.archives@nara.gov. There's no dash or hyphen in Kansas City. It's Kansas City just straight. kansascity.archives@nara.gov. Now, while what we have off-site are the granted case files, there are other pertinent records at the National Archives in College Park. Notably, there's a unique series of patent drawings from 1836 to about 1900 for the utility inventions and 1843 to about 1900 for the design. These are basically larger versions of the published letters patent. These are held with our cartographic reference services, and when submitting your inquiry, you want to be specific that you're not referring to the records in Kansas City or due to the way you will likely be forwarded to me. So just be very specific in that. In addition, if you're searching into other records like the Patent Assignment Digest, which relate to who was initially assigned the rights to a patent, or infringement case files, those are going to be under our textual reference division. If you ever have any questions about this, email the National Archives of Kansas City, and we'll at least be able to put you on the right path if for some reason you get bounced to us. So it's not something we're worried about, and we're very glad to help. And I've also included a sample request with just a tagline noting that the records you are seeking are in College Park and are a different series from the ones held in Kansas City. That will be an important distinction to make. So as I mentioned, there's some opportunities for further research. There's the other NARA record series. The patent lawsuits can often yield very interesting results, as well as the cartographic drawings. Those would be the two that I would really highlight for genealogy benefits. You can also look up, potentially other international archives and patent offices. That is something where you will find other results, sometimes related to your ancestor. I will note I have heard from international requests that not all patent offices have their records kept like the National Archives does. So that is something important to note. Depending on how successful and how much you really want to search into it, you could look up the personal papers of the notary public who initially reviewed the application, as well as the patent attorney that your ancestor used. And that just depends on how much resources you want to invest and whether or not those records even exist. Those are going to probably be held at local county historical societies, and maybe if they were a very prominent attorney, potentially a university. There is also libraries can become a patent and trademark resource center. They're specifically designed to help the public learn more about patent information and law, and they keep all current information for at least 20 years, so for the last 20 years of patent records that are granted. And if you follow this website, that will tell you more about the resource centers and what you can expect to find. Another really good thing about starting to do research with patent records is there's actually a lot that's available online, and they're really fun and popular. The Archivist of the United States occasionally will put out a patent of the month of an interesting request that they have for a digital record. I've included a list of series that you can find in the Guide to Federal Records. We also have a lot of records related to African American inventors, and I've linked to a blog that contains unique patent numbers for early inventors. There's also a lot of information that's just been written about patents. This has been something that has captured the American psyche more or less since they first started granting patents in 1790. And so just get out there, start searching, and have some fun with it. If you'd like to connect with the National Archives at Kansas City, you can go to our website. We are also active on Facebook and Twitter, and these are great ways to see what's going on with us, learn about events, and also a great way to highlight our records. So with that, I'm going to start with questions, and before I get to that directly, I would be remiss if I did not show this letterhead. This is one of the favorite patents I've ever got to work on. This was a patent that was granted to Nikola Tesla for vertical and horizontal takeoff aircraft. It was filed in 1921 is when he applied for the patent, and it was not granted until 1928. That is incredibly rare. The patent was initially not accepted, and this letterhead comes from a handwritten letter that Nikola Tesla wrote to the Commissioner of Patents arguing for the reason for his patent to be granted. And it's just an example of things that you don't expect to find when you open up a case file. And even more fun for me is that this was his second to last U.S. patent that was granted, and was actually, of course, his very last one was granted just after this. And so with that, I would like to open it up to questions.
Hello, Christopher.
Hello.
Before we get into your Q&A session, I have a nice comment that I'd like to share with you that came in from one of our audience viewers. They said, "Thank you for clarifying patents and patent land records. Until I saw the record, I thought my great-grandfather was an inventor."
That's common. That's very common, and I'm glad to help.
So your very first question is, when again did patents begin?
The first patent in the United States was granted in 1790. Patents from the period 1790 to 1836 were actually destroyed in a fire in December of that year. And the ones that have been reconstituted have an X. These are held, the ones that have been reconstituted are held at the National Archives at College Park. Patent number 1 was also granted in July of 1836, but was not destroyed. And that is what starts being held out with me off-site. So 1790 to 1836, there's about 30% of the records are still available to some form. And then after that, we have just about every patent granted between 1836 and March of 1976 out here in Kansas City. There are selected patents, very selected patents that are retained at the vault in College Park. These are Thomas Edison's patents, as well as some other high-profile inventions. For example, George Washington Carver, while a prolific inventor, only received 2 patents. Those are held there, but you're still going to find a lot of very high-profile inventors. We could just go on and on and on with the bulk of research that's available. And I want to add one more thing too. If you're doing county histories, these are also a really fun record to learn about famous citizens of your county or the areas you lived in. So that's another avenue to follow through on.
Your next question, are there different patent laws for drug companies?
No. The patent law is basically, if you get assigned a patent, that you get granted that exclusive right for the period of time. I believe right now it's 17 or 20 years for current patents, and so you are granted that exclusive right. It's the same if you were to invent an improvement in baseball gloves. You would be given that right for the same period of time as any other individual or corporation. And I can actually say we do have patents out here in the utility series for medical inventions.
What is the cost for a copy of a full case file, and will NARA tell the researcher how many pages are in the file?
We do a price per page. That's a very good question. So we have a minimum order fee of $20 for orders 25 pages or less. Above that, it's 80 cents per page. So roughly, it's 80 cents per page. So if you have a patent that is 26 pages, it's $20.80 for us to provide copies. If it's 100 pages, it's $80. So it's a per page fee. It's a very good question.
Your next question. I had an ancestor who invented a new type of barbed wire, but I couldn't find any patent for it and I'm wondering why.
It's one of those things where maybe they felt that they couldn't get the granted right. Maybe they were advised that it was too close. My great-great-grandfather invented a tool for barbecuing and tried to patent it and was told that, someone about 30 years before you got a patent similar to this, it'll probably be rejected, and if you patent it, someone's just going to knock it off anyways, so your best bet is just to produce it and do it well. The reason for not applying would be up to your ancestor. Now, I hope that helps answer.
Your next question. I know one of my ancestors created the very first electric cigar lighter, and there were 6 improvements. How do I find the patent number?
So if you have the patent number, or if you know that your ancestor granted a patent, I really suggest starting with Google Patents and doing creative searches using your ancestor's initials and last name and location of where they lived. If you know the company they worked for, that might even be a good place to start too. You will be able to probably, if you know that happened, that would be my suggestion. If you need some more guidance about how to do some searching, please email kansascity.archives@nara.gov. Or if you send it to the Inquire account, it will come to us eventually. And if you could do that, I'll be glad to send some more direct pointers and work with you to figure out what we need to find.
The next question. When more than one inventor is involved with a patent, is the document indexed under both names?
Online, yes. If there were 2 inventors who were granted together, yes. You will have all of the people who were assigned with the invention should be listed on that patent if they were involved with the invention. And you'll see that with companies. Often they'll have multiple inventors. So you should be able to find out through online searches. They should still be on there.
Could a product or process in making it used in food during the 1880s be patented?
Yes. There was a patent for Kraft's pasteurized cheese. So it's one of those things. Anything can be patented. You can find any type of information pretty much in these records. There's been patents about archival boxes. There's been patents about pinecone toy turkeys, cheese presses, guns. Ordnance is a very big research topic that I get of. People who are very interested in historic guns will like to see, oh, I want the Christian Sharps rifle patent, or a specific gun that they used, their grandfathers used during World War II, and we can kind of go through and work with people to find stuff like that. It's not uncommon. So food processes, it's possible. I can't say it's guaranteed, because when a person creates a patent, they're making it publicly available how to do it. So oftentimes food would want to be, I guess, a trade secret. That's the same thing with Coke's formula. Everyone wants Coke's patent formula. Well, they don't have a patented formula. It's protected by trade secret. They keep it underneath their own lock and key. And while that's great because they don't have to disseminate how they make their product, if it were to get out, they're not afforded protections.
Do trademarks require another process?
Trademarks are actually not permanently retained. Trademarks can still be active from the 1800s. I believe the oldest active trademark is from about 1880, or 1860, sorry. Those are not permanently retained. We have a sample of trademarks available at the National Archives at College Park, but that's not as common. The records there are much fewer.
The next question, are files available for denied patents?
We have very select patents that they're called abandoned patents that were cited in granted patents. It's abandoned application, cited and granted patents is its full series. Those are very select records and are not comprehensive. It is very piecemeal what we have, and we really only document about 10,000 or so patents, probably between the 1920s and the 1960s. So those are not something we can guarantee. And again, one of the things we would have to find is the serial number that was given to it when it was applied for. If you can find in a serial number, I'm glad to search through our records and see if we have it. But especially with abandoned applications, it's the chances for genealogical benefit are much smaller.
When requesting a patent search, would you prefer the filing date or the publication date for searching?
If you have the publication date, would be the best one, because a patent could be filed in like the Nikola Tesla patent that I showed, the letterhead from that. It was filed in 1921, but not granted until 1928. And so in 1928 is when it would be given its unique granted number. And that's what we need, is that granted number or the granted date. If you have a granted date, I can do a very limited search and do a hard search and see if it can be found. If you have the publication date, though, that would really go a long way, because we could do online searches and probably find it fairly easily.
The next question. How do we know which office the patent is held in?
Contact us. Contact the National Archives at Kansas City. We hold about probably 99.9% of the patents granted from 1836 to 1976. They are held off-site in multiple facilities. So you contact us, we will get you in touch with the archivist who will help you. And odds are you'll be working with me, but there is a colleague of mine at another facility where they're held. So unless it's a very high value one, and if it is, and it's protected in the vault, I will direct you directly to the NARA staff person who can help provide access to that. If it's a patent that we have not yet taken in, I'm glad to provides you the contact for the U.S. Patent Office and how to get it searched and ordered through them.
I have a couple of other questions from your audience members. One says, I have friends in the computer industry who are getting patents now. When might historians of the future be able to see their files in the National Archives?
Once they're granted, you can get them through the U.S. Patent Office. Generally, NARA does not take patents in until they're about 40 years old. Once they hit 40 years, they're eligible to come to the National Archives. Or about 40 years, they're eligible to come. So we don't have privacy concerns because the files are so old by the time they come to us. Because it's important to remember, when the National Archives takes records, they're supposed to have fulfilled their administrative need for creation. And since patent records have a life of about 20 years, the Patent Office needs to know what happens with that. So about 15 to 20 years after that, they can come to the National Archives because they're no longer needed for current business. So your friends who are getting patents now, if you use Google Patents, you can find if they have a patent granted, you can find it. If you go to the Patent Office's website, you can find at least the published images of their patents. I found other family members, including my dad and my uncle, have patents that aren't yet eligible to come to the National Archives, but I have found their patents online through searches. And so you can find those now, and if you need some tips about that, email us, and I'm glad to provide them.
Here's another question from one of your audience members. I have a son who got a patent for technology, but it would be done by his company. How do I search for the patent? By the company or by my son's name? And would both names be listed?
Potentially, yes. A lot would depend on your son's role. Sometimes, especially with companies or if you're working with a federal agency, so let's do a hypothetical situation that I invent a new archival box. So when I apply and I get my granted patent, it would say, I, Christopher Magee, assign to the National Archives and Records Administration the rights to this patent. So they would both be potentially included in searching, especially if it's a more recent file. That's more and more common. I would suggest starting with the company name and the date, and then adding the person you're looking for, adding their name in as an additional search term, and seeing what you can find.
Christopher, this is your final question.
All right.
On Willie J. Magee's published patent, I noticed two names mentioned at the end as well. What role did these people play in the patent process?
Those were the initial witnesses. Here, if you let me, I can switch to the PC. Or here. Here, hold on, just a second.
Christopher?
Yes.
Christopher, we're not sure if our AV staff can follow you.
Okay. Oh, that's right. You have.
Because
sorry about that.
They're mirroring you, and I don't think they have that presentation up now.
Okay. So what I can say, well, I pulled it up for me, and I can see. So at the bottom, there's 4 names on his letter's patent. There's William J. Magee. There is C.A. Snow and Company by his attorneys. And then there are 2 witnesses. Those 2 witnesses are the persons who attest. They're legally saying, we also believe that William Magee is the inventor. And I'm switching over to the VTC controls. I don't know if that helps. You have it on the Google Patents. So that's one of those. That is a way to find your ancestors too. And I have not found anyone in my line, but a great thing about Google Patents is those names are searchable as well. So if you even know who someone your family was associated with, there's still at least ways to see how they were represented in the community at large. So there's just untold opportunities for interactions. Like I said, we have over 4 million files in our holdings now. And if you think about that, that's a lot of opportunity for interactions with the federal government. And it could be anywhere. It could be a national. I have worked with people internationally trying to find, I worked with an Australian person trying to find information about their German grandparent through the United States Patent Office. And you can do that. And it's untold opportunities.
Thank you, Christopher. And now Bill Mayer, our Executive for Research Services, will close this phenomenal event.
3 days of sessions we've just shared together. You must be exhausted. My name is Bill Mayer, and I am the Executive for Research Services here at the National Archives. I have the pleasure of working with all the people who've been speaking to you over the last 3 days. I want to thank all of our presenters, our partners, and especially the team that brought this all together. Diane Dimkoff, Andrea Matney, Rebecca Sharp, all shored up by our technology and social media teams. Truly, bringing all this information to you, the public, is a shining example of the talented and dedicated federal staff who ensure the permanently valuable records of the United States are cared for and made accessible. And we do that good work any way we can. While we have at our heart the notion that what is past is prologue, with this genealogy fair, I can happily tell you that the future is now. Over these past 3 days, we've reached over 5,000 people a day from over 30 countries. That's far more than we could ever reach in an individual classroom or even from the theater from which we're broadcasting today. Check the Twitter feed. I am so proud of the efforts of our staff, and their love for your records is what has made these 3 days so memorable. Your engagement with us online, your comments, questions, tips, and tricks also show us the true power of these online communities. So I can tell you that the slides from the fair and the presentations are going to be mounted on archives.gov. They'll be accessible there, as will the slides and presentations from last year. Please check them out, and I can promise you all there is much, much more to come. Thank you all, and farewell.